So, hello everybody. Thanks for joining. It's the last Wednesday of August at lunchtime. It's high time for the 25th edition of the Swiss Patent Litigation Fireside Chat. It's lunchtime, but maybe you better grab a cup of coffee. It's pretty much about coffee this time. As always, there is a comments section on LinkedIn. So if you want to leave a comment, have a question, or whatever, just leave your comment there, and I will have an eye on that, and hopefully we'll have a chance to pick it up during the session, or I will do that later, of course. So as I said, it's pretty much about coffee this time. So the first case is indeed already about coffee. Uh, it's about these aluminum coffee capsules of Delica. That case is the case number S2022-009. That's litigation between JDE and Delica. The coffee capsules are known in Switzerland as Café Royal coffee capsules. They are made from aluminum and they are compatible with the classic Nespresso system. Now, all these coffee capsules, on the top of the capsules, there is a sealing foil, and that part of the capsules have to be sealed against the machine. You can see that in an enlarged view. When you look from the bottom under the rim, there is a lot of magic happening with troughs and rims and sidewalls. And I really don't want to go into much detail here because I need to make a disclaimer notice upfront. Our firm was involved in this litigation, so I will really only report about the facts from the decision. It's the judgment that contains this figure here. On the left side, there is a sketch with some colorations added, but the sketch is from a prior art document, an old German prior art document. You can see the rim. The bottom here is on the top, so it's turned upside down, the capsule. And you can also see there is troughs and rims and sidewalls, and in the middle there is a figure from the patent in suit. And well, yeah, it somehow looks similar. I will come to that in a minute. And on the right side there is a cross section through the attacked embodiment, the aluminum capsule of Delica. Yeah, the judgment holds that the patent in suit is invalid because it's obvious over this old German prior art document. The only distinguishing feature over that document was the thickness of the material, which was held to be obvious in the end. So the infringement itself is not dealt with in the judgment, but there are some considerations about claim construction, and I think the section about statements of purpose is maybe of broader interest. You can see that on the left side and in the middle of this picture here. If you look on the left side on top, there is well, it's called an engaging member. That is not part of the capsule that is claimed in the patent in suit, but rather it's a part of the machine that then seals the capsule in the machine before it's extracted. And this engaging member of the machine, of course, is not part of the capsule claim. But the claim says that the capsule is, hold on a second, adapted to undergo plastic deformation during closure of the enclosing member. As I said, the enclosing member is not part of the claim, not part of the capsule, and the capsule shall be adapted to undergo plastical deformation. It's again a reminder in that decision that this does not mean that this plastic deformation has to indeed occur during closure of the engaging member when it is used as it is used in the market, but it just has to be suitable to be plastically deformed when an engagement member of some kind is lowered on that rim. So yeah, that's nothing new under the sun. I think it's just a common interpretation of statements of purpose, Zweckangaben, as it's known, for instance, from the EPO. So this PI request was accordingly then dismissed because the patent was held to be likely invalid. The next case is litigation between Bayer and Acino. That's about Bayer's blockbuster pharmaceutical Xarelto. This is, I think, really by far Bayer's most important pharmaceutical. There is currently still an SPC in force in Switzerland that still runs until, I think it's June next year, June 2024. There are already some generics that have applied for a market authorization and already have or hold market authorizations for rivaroxaban, but they are not on the market yet. So I believe that apparently this SPC is respected to date. But the bone of contention here between Bayer and Acino was a so-called license offer of Acino. I need to take that away here. In the last line, you can see this rivaroxaban with new in brackets as part of Acino's license offer. Now, what is this license offer all about? Acino obviously as a offer some sort of generics as a service. They offer to take care of the whole dossier to be submitted to Swissmedic in order to get a market approval, to take care of all the regulatory things that need to be complied with, to take care of manufacturing, packaging, and so on. So it's really kind of a full service package for other generics who want to come on the market with rivaroxaban. Now, it is an offer, of course. It's an offer to license, to out license this whole package. But as part of this whole package, it contains the application for a market approval. Now, what did the FPC do with that? So it's common practice in Switzerland that even holding a market authorization is not yet an imminent threat that this generic company would come to market. It's only when it's listed in the lists of refundable pharmaceuticals that constitutes then a risk that the market entry is imminent. So since there was no indication that potential customers of this licensing offer, when they would then, as part of the licensing offer, would hold a market authorization, that they would then not respect the SPC that is still in force in Switzerland, as all the other generics that already hold market authorizations, that they would not respect that. So the judgment holds that there is no imminent threat of a market entry as part of this out licensing offer, and therefore the request for an ex parte PI was rejected. And from the fact that the FPC published this decision rejecting an ex parte PI request, I take that there is most likely no inter partes PI request pending, because normally the FPC only publishes the ex parte order or decision together with the inter partes decision. But here the ex parte decision was published. So I think that's all we will get to see from this case. Now, there's one thing I wanted to say about that. Maybe it comes to mind later. So this case is most likely finished, and the next case is about e-bikes. These kinds of e-bikes from Revolt Cycling. That's the company manufacturing these e-bikes. The brand of this bikes is Opium. So it's one of the most far-reaching e-bikes. Apparently, they can run, I think, more than 800 kilometers on highest capacity. So this was litigation between myStromer, that's the company who manufactures the Stromer bikes, against Revolt Cycling, manufacturing the Opium bikes. So the case number in Switzerland is S2023-002. This is about a saisie helvétique. That's a precise description. If you have never heard about the saisie helvétique, if you can provide or can make it plausible that there is most likely an infringement, but you are still lacking some essential information and you can't get hold of this information, there is a possibility for this so-called saisie helvétique, where then a court delegation enters as a surprising visit at the premises of the defendant and asks for this information, and then there is made a protocol about what has been spotted on this potentially infringing device, and then the requesting party of that saisie has to see what it does subsequently with the information collected during such a saisie. It's maybe most meaningful to discuss this case on a broader scale, because what I've already reported on the blog is that Stromer actually obtained a PI, an ex parte PI at the UPC. That was the first ex parte PI issued by the Unified Patent Court. That was in Düsseldorf, I think, and that was immediately before the Eurobike trade fair, and Stromer actually enforced this ex parte PI and effectively closed down the booth of Opium bikes during the trade fair. And the saisie helvétique happened a few days before this trade fair, and at the very same day of this saisie helvétique, Opium had submitted a protective letter to the UPC in order to prevent an ex parte PI, obviously, but that ex parte PI nevertheless was issued. But what Opium argued to the UPC in the protective letter was about this feature here, namely that the second fork is recessed with an internal thread hole corresponding actually to the through hole. That is a feature of the claim. I won't bother you with all the further details, but what Opium said is, well, we are not fulfilling this feature with the construction in our Opium bikes. So that was essentially the non-infringement argument. Now, putting a bit context to that, you can see the fork here. That's the rear fork, and on the right side, and I put a little bit of coloration. The coloration is by me. You can see the recess in the fork that is in bluish color, and then you can see the internal thread hole 121. That's in dark green. That is in the recessed fork, and in orange there is this axle that is going inside of that thread hole, and it's fixed therein. So Opium said, well, we are not doing it that way. What they said, what they do is they fix the axle not in the fork, but they fix it in a torque sensor. Now, having a look at the figures in the judgment of the Federal Patent Court, again, this is the other side of the rear fork. You can see the axle is apparently fixed in a through hole. So in German Steckachse, that is pretty common. But the other side is a more interesting one. That is a picture that I grabbed from the internet from before the Eurobike. That's one of the early pictures from the opium bikes. That's the interesting side of the fork. Yeah, it's covered with a apparently a plastic covering in black. It would be highly interesting to see what's indeed under this plastic cover, but we simply don't know. Apparently, Opium argues, well, there is a torque sensor, and this axle is fixed in the torque sensor, not in the fork. But still, despite they feel they are not infringing with their construction, they made a change to their construction, and what they have now on the website is this picture here, and I need to put the icon away here. What they put in the picture on the very left downside is marked as a new dropout technology, they call it. And you can see that there is on the bottom there is a welding seam where they apparently have replaced the dropout construction as a matter of precaution. Maybe we simply can't know. Yeah, that's what I can tell for now about the UPC and the CESI. Maybe one interesting thing from the CESI is the final decision on the CESI also deals with an aspect of the minutes of the CESI. To put that into perspective, when a CESI is happening, that there will be established minutes by the court delegation to put down in writing and pictures what they have seen and identified on the spot. And later these minutes are forwarded to the defendant, and then there is a whole bunch of discussion always whether there are still confidential information, trade secrets of some kind in the minutes that need to be redacted because they have no bearing on the issue at stake. And at some point there will be an agreement or a decision by the court about whether or not some information is to be redacted or not. Here, the minutes apparently held in some points that the axle is fixed on the right side of the no, not of the fork, but it's fixed in a mounting plate for the axle, in German Achsmontageplatte. And the defendant later objected to that term and said, well, that's not a suitable term for that. Let's call it a torque sensor, because Achsmontageplatte, mounting plate for the axle, does not give it the right name. It prejudices the function of that item in an inappropriate way. Now, the FPC did not buy into that argument. They simply said, well, you signed the minutes on the spot and you did not object to that term. And now we are only talking about whether or not there is confidential information, trade secrets, any need for redactions, but we are not changing any terms now. And claim construction and the understanding of the terms as they are used in the minutes, that's a matter of the decision of the court on the merits afterwards, when a request for a PI or ordinary proceedings are brought before the court. Which brings me to the next point. I took from some press releases of the defendant that apparently also an ex parte PI was sought for by Stromer in Switzerland, like at the UPC, but that an ex parte PI was not granted in Switzerland, which is not really a surprise to me. That really rarely happens in cases like this kind, where there is really a need in order to come up with a reasoned decision to discuss technical issues that are still to be decided on, and which are not really apparent. Which brings me to the next point: what the UPC held. As I mentioned earlier, the the defendant Revolt said, well, we are not having the axle fixed in a recessed portion of the fork, but rather in a torque sensor. Here is what the UPC did with that. It's just one paragraph in the ex parte PI that they issued, and they said, well, they are not seriously disputing infringement, and the last sentence struck me. They only said, well, you say it's fixed in a torque sensor, but the patent does not exclude that the fork is made up from multiple pieces. So I take from that that they just think the torque sensor is just a part of the second fork. Yeah, that's pretty much all that is in the ex parte decision of the UPC. What I was missing is claim construction. It's just a statement. I found that pretty bold, but yeah, that's the way this ex parte PI was issued. I made a blog post about that case, and you might want to have a read of that blog post. That UPC ex parte PI struck me for various reasons. It's apparently only for the big boys with the deep pockets, because 500K of security had to be provided. No technical judge was involved, and there were a lot of details that I've found, well, yeah, not so ideal, but have a read and then make up your mind yourself about that ex parte PI. My best guess is that inter partes PI proceedings are currently ongoing in Switzerland, and I'm eager to see how that finally unfolds. So, which brings me to the next coffee case, which is litigation between Nestlé and KFI. That is case number 02022-003. If you feel that's a déjà vu, you're probably right, because there has been litigation between Nestlé and KFI. Well, the other way around, KFI against Nestlé, in infringement proceedings. That infringement proceedings, they have been decided in first instance, I think it was in May already. And in that decision, the Federal Patent Court held, well, the three patents in suit, they claim a barcode at the rim of a coffee capsule, and what the Vertuo pods, the Vertuo pods of Nestlé have on the rim is a bit code, not a barcode. And there's a difference between a barcode and a bit code. Therefore, there is no infringement. So that, in short, was a decision in infringement proceedings. The appeal is currently pending at the Supreme Court. We will need to see how that plays out. But there is also these proceedings that were pending, which are ownership proceedings, because Nestlé sued KFI for assignment of the exactly three patents, because Nestlé felt, well, they belong to us. Now, how comes that's a pretty difficult setup? But maybe let's have a look at the patent family. That's a funny section in a way in the decision. The decision holds that this is a simplified, in quotation marks, a simplified version of the patent family, overview of the patent family, and the three patents in suit are marked in red. So the assignment action is only about the Swiss and Liechtenstein parts of the three European patents at stake here. And I understand that the whole rest of the patent family is currently being litigated at the regional court in Düsseldorf. So now, what is this ownership dispute all about? In a nutshell, Nestlé's argument was as follows: they had this internal project of these coffee capsules with a bit code, and then they took on board a Swiss engineering company, Helbling, and they co-developed then this system together. And they came up with a huge book, not a report, it's actually a book from the number of pages mentioned in the decision. And this report then, when it was on the table, well, they also needed a machine, a coffee machine for that. And that was the time when yet another company came into play, which is referred to as Company A in the decision, but it's it's an open secret that this is the company Oyster Frismark. And Nestlé only learned later that Oyster Frismark also was in close cooperation with KFI at the time. And Nestlé now argues that the information was somehow passed on from Oyster Frismark to KFI. And that's the way how KFI got hold of this information. And now these patents that are the fruit of this information that was passed on to them via Helbling and Oyster Frismark has to be assigned to Nestlé. Now, as a quick reminder of how the Swiss Federal Patent Court looks at these assignment actions, there are actually 4 steps. It's a 4-prong test to be passed in order to have a patent application assigned. The first criterion is, well, you need to make a showing and to prove which inventor has made which invention at which time. So it's first about who came up with what. And then if the plaintiff is not the inventor himself, it has to be shown how the plaintiff obtained the right in the inventions made by the inventors. That's a second criterion. And then the third criterion is, well, it's difficult here on the slide, it's pretty lengthy, but you need to make a showing and to prove how that information then was passed on to the allegedly unlawful applicant. And only then the fourth criterion, need to take that away here. The fourth criterion then the check for identity. Well, is that information about the invention that has been made available to the allegedly unlawful applicant, is that in the end then indeed the subject matter that is claimed in the patent applications in suit? So from these 4 steps, only the second step really is being looked at in the decision. That is where Nestlé in this case failed. And why did it fail? It was a hugely complicated setup with a lot of inventors being involved, both on Nestlé and Nespresso side and on the side of Helbling. And the first hurdle for Nestlé was, well, they could not really prove which inventor contributed which element to the invention. It was kind of a collective that came up with the inventions, and the Federal Patent Court in the decision acknowledges, well, in such a setup, it is sufficient if you can just show they all were involved there, and they all have assigned their rights to the plaintiff. Then it really doesn't matter who contributed what. When they all assigned whatever they did, then it's okay. But still, Nestlé had severe struggles because they did not they were not able to prove that all of the alleged inventors on behalf of Helbling were employed by Helbling and had assigned their rights first to Helbling and then later to Nestlé and Nespresso. So it failed at that stage for the external inventors on behalf of Helbling. And that's essentially where the judgment stops. They failed to prove the second criterion, and therefore the assignment action was dismissed. To the extent the Swiss and Liechtenstein parts of these European patents were concerned. Yep, that's it for that decision. And the last case I wanted to quickly touch upon is not yet a decision. It's just a forthcoming hearing. It's a main hearing in a rare case where parties that have already litigated about infringement still need a hearing about damages. So that's litigation between CNE Fein and Robert Bosch. And the defendant, the unlucky defendant, is Coram Tools. And Coram Tools has been held to infringe on the patent of CNE Fein and Bosch, but the parties apparently still are in disagreement about the damages. And this hearing is scheduled for the 14th of September. And to the best of my knowledge, it would be the first main hearing in the second stage of infringement proceedings, only about the amount of damages. So if that hearing really takes place, maybe they are still in discussions, but maybe that's the first case where the hearing actually takes place, and I will definitely have a look, and with it, this hearing might be interesting. So mentioning the 14th of September brings me to a last reminder. There on the 14th of September in the evening, there is this annual evening seminar where Tobias Brehmy, the second ordinary judge of the Federal Patent Court, gives a presentation about the case law of last year. It's a FESPA evening seminar in Zurich. You can still sign up for that one. I definitely recommend to do that. That's one of the must-go events of the year if you are into patent litigation. And the other event is a day before, a day earlier. That's an AIPPI event in Bern, where Sven Bucher from the Federal Patent Court, alongside with Meinrad Vetter and Mr. Josi from the Commercial Court of Aargau and Bern, is talking about provisional measures. And from the Federal Patent Court, it's the Saisi Helvetiques that will be explained. Most likely, it's a Stromer case on which Sven Bucher will expand. And register bans is also a provisional measure that will be addressed. So I will leave it at that. It's already a quarter to one. That was the lunch break on the last Wednesday of the year of the month of August. I hope to see you next month again, and thanks for joining, and enjoy the rest of the day. Thanks, and bye-bye.